Hello, my name is Andrew Yamayaro. I'm a solicitor at Law Solicitors, and today we want to discuss on a topic about people that have got properties in multiple jurisdictions. If you've got properties, for example, in England, Zimbabwe, Nigeria, Portugal, different places, and you want to know how you can deal with your properties in terms of your will when you pass away. So today that is the topic that we are going to discuss. The topic about people that have got properties in multiple jurisdictions, the complications, the advantages, and the disadvantages. As you can see on the screen, the topic is what happens when you own properties in different countries, understanding wills, inheritance tax, and estate management, particularly in England and Wales, which is where I am based. Why does this matter? In the modern world, it is quite common for people to own properties in different countries. Someone who might have emanated originally from India or Pakistan or from Zimbabwe or Nigeria, any other country, will feel obliged or of necessity to have a property or properties from their own home country, as much as they will be staying in the United Kingdom or in England and Wales where they will have a property. Some people are buying investment properties in other countries. So people might have properties in Spain, Portugal, South Africa, holiday destinations, and they've got these investments that they are doing in different countries. What this means is that different countries have got different rules. So the laws that will apply when it comes to succession and probate in different countries is also different. That is why it is important to consider this topic on how your assets, your properties, your investments in different countries can be dealt with in terms of your will or distribution of your estate when you pass away. What is a will? It is a legal document that says who gets what things when you die out. In the will, you express your wishes as to how your properties, your estate is going to be distributed, and how your body is going to be dealt with, how your funeral is going to be conducted, who is going to be looking after your children, who is going to get what and when. Those are the things that are normally included in a will. And wills have got legal requirements according to the laws of each particular country. So the laws that might be applicable in England might not be applicable in another country because of the different jurisdictions or because of the different majority beliefs in that particular country. So for that reason, you may need a will in each country in which you own a property. This prevents confusion and delays. It is possible, as I will explain later, to have one will, but in my advice, it's always best to consider the legal ramifications of having one will in different countries that have got different laws, different requirements for a will to be valid, and how it can be enforced, and inheritance laws, and so forth. So, in my humble submission, having multiple wills that are not contradictory but are referring to each other is the best way to proceed. If you own properties abroad, the laws in different countries affect your properties differently. Some countries, like France, have got forced heir rules. In England and Wales, you can choose who inherits. But again, there is the international conventions that are there when it comes to enforcement, recognition, and so forth of wills, judgments, etc. But it is important to know that each country has got different laws on how succession or probate may have to be conducted. And some countries may be signatories to some international conventions, which might make it easier. Properties in England and Wales follow the English law, and properties abroad follow the laws of the country where the property is situated. And therefore, even under in private international law, a lot of things have to be considered, including the domicile of the person, the habitual residence of the person, where the property is situated, because that will determine how the property is going to be dealt with when someone passes away or when someone's estate is going to be dealt with. Movable assets like money and cars follow the country of your domicile. And again, this is a complicated topic. Domicile can be different. You've got domicile of birth, domicile of choice, and the domicile of dependency. These are things that are also different, and it will take a lot of time to discuss and debate about domicile. So your estate can consist of several things. That can be your money, your property, your possessions, different forms and formats. It can be shares, investments, buildings, cars, and so forth. So different possessions that you have. So what happens to your estate? The first thing that you need to do is to find the will and then apply for probate. Probate in other countries is called succession. Then the estate is evaluated, and the value of the estate has got different brackets in which taxes might apply, taxes such as inheritance tax in England and Wales. And if some of the properties are going to be disposed or dealt with, then there could be issues to deal with capital gains tax, etc. So it's important to know about estate planning when you are dealing with the estate. When the executor, the person that is dealing with the estate when you've died with a will, is dealing with the estate, then they will have to first of all clear or deal with the obligations, legal obligations or liabilities of the estate before they can distribute the net estate to the beneficiaries. An executor is appointed in terms of the will. When someone dies without a will, that person has died intestate. That means that they do not have a will. And the court and an application or a process has to be followed whereby an administrator is appointed, and there are strict rules to be followed where someone dies without a will, because the justice rules are not always fair and they do not follow the wishes of the deceased. That is why it is important for someone to have a will. The distribution of the estate of the assets will depend on whether someone has died intestate or someone has died with a will. Where someone is died with a will, it's normally the wishes of the will of the person that has made the will that is followed. And if anyone was dependent on the deceased and they've been left out of benefiting from the will, then there is laws that are there that can help them to claim from the estate for the family provisions, etc. But under in testacy, there is a strict regime that has to be followed, which I've previously discussed in some of the presentations that I've done in the past. So the big question really is, can I have one will or multiple wills if I've got properties in two or more jurisdictions? You can make one will for all property. It could be easier to manage, but it might not be accepted in all the countries because of the laws that are different in terms of how it is executed, how it is how it is accepted, the legal requirements of a will and how it is enforced and so forth. It might be different from country to country. That's why, in my view, it is important to have multiple wills so that they can be followed according to the local laws, and there's no risk of. You have to eliminate the risk of conflict by carefully wording the wills. For example, each will has to refer to the other will in whichever jurisdiction that you are dealing with, so that it can be recognized that there is more than one will. In terms of international succession rules, again, each country has got its own succession rules, it has got its own probate rules, and there is international conventions that are there. For example, the EU Succession Regulation Brussels 4 and there is other laws that are applicable. We have to remember that the UK is no longer part of EU. They came out of the EU after Brexit, and they have done some transitional arrangements, and they keep on trying to implement new um, ways of cooperating with EU and so forth. So we have to recognize that the UK is now a standalone country, and therefore it could be in terms of international conventions or referring to the local laws of each particular country that you have to deal with your estate and your will. I've explained the impact of Brexit. UK is no longer part of it, and then if there's anything that needs to be dealt, you have to consider the international laws as they are. In terms of inheritance tax, and in terms of all the tax and liabilities and obligations that the estate might have, it is important to seek legal advice so that you make the most benefit out of the estate before the taxes have been taken out. So there is a lot of planning that needs to go into someone's estate when they are still alive and when they pass away. It's important to recognize that when you're still alive, you can start distributing your estate in accordance with the law. For example, you can give small gifts to your family. You can give gifts of about £250 to different people, about 3,000 pounds to your children and so forth. And then there's the 7 year rule that applies and so forth. You need to get advice. Landlord solicitors can advise you on this and on how the estate will be dealt with when you've passed away. Does it have to be distributed, all of it? Does it have to be put in a trust? And how is the trust going to be managed and so forth? So we need to make plans for the taxes, and the major tax here being inheritance tax, and the threshold being 325,000, and above that it goes up to 40% of the tax. Spouses and some charitable donations are exempt. And again, we have to be careful of the law as it applies to intestacy as well. It's important for you to get legal advice and financial advice. There's some financial advisors that deal with succession um, laws or succession rights or succession issues financially, so that you do not end up being double taxed, for example, or avoiding a tax or getting liabilities, because countries may charge inheritance tax. You might be charged twice, um, or if there is a benefit that you might be entitled to, you might end up missing in that particular benefit in terms of um, tax efficiency when it comes to estates and your inheritance. It is important to plan ahead. That's why I'm saying today you need to write a will. You need to consult a planner, a tax planner. You need to consult a lawyer. You need to consult a financial advisor. When you do your wills, make sure that they refer to each other. Get legal advice in each particular country. You might get someone that might have dual qualification. For example, myself, I'm a solicitor in the UK, and I'm also a legal practitioner in Zimbabwe, non-practicing in Zimbabwe, but I know the law of Zimbabwe. So you might benefit from going to someone who knows the laws of both jurisdictions. But if you've got more properties, then you might need to consult more than one lawyer, depending on the need that is at hand. Use legal tools to reduce tax. You might give, as I was trying to explain before, you might give gifts, you make trusts, and there are allowances that are there that can be used so that you are avoiding the liabilities of tax. What are the takeaway points? Owning property abroad makes estate planning more complex, hence, you need advice. Planning ahead with the right wills is important. You need to understand the tax in each jurisdiction. Seek professional advice to protect your assets. Not only your assets and your family as well, or your beneficiaries, they need to be protected. If you need any assistance, at Channel Solicitors, we are there to help you. We deal with wills and we deal with probate and succession. We have got clients that are all over the world that we have helped in their various matters. If it's something that we cannot deal with ourselves, we are more than happy to refer you to our colleagues within the profession that can be able to help you. Thank you so much for tuning in. Please subscribe to our YouTube channel. We have got a lot of videos on there that can benefit you. Until next time, thank you.